Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about offences relating to newborn or unborn child. It is a natural thing that one who has taken birth has to die, but an act leading to the death of an unborn or newborn child is not cogitable. One of the very probable reasons for the said offence is the desire of having a male child, as it is considered that a male child will take care of his parents in their older days. It is a harsh reality that we live in a country where goddesses are prayed but girl children are killed in the womb or in their very starting days of birth. Offences against unborn child. The offences related to homicide of unborn or newborn child are dealt in section 312 to 318 of chapter of the Indian Penal Code 1860, that is causing miscarriage, act done with intention of causing death, exposure or leaving of a child with intention to abandon and concealing birth by secretly disposing of a dead body. Causing miscarriage. The term miscarriage is not defined under this code. In legal terms, miscarriage refers to the deliberate termination of women's pregnancy before entire development of the child. It can also be referred as spontaneous abortion. These offences are defined under section 312 to 314 of the code. It deals with causing of miscarriage on the basis of its gravity. The punishment under section 312 differs for women with child that is being pregnant and quick with child that is advanced stage of pregnancy when movement of fetus can be felt. But the punishment under section 313 has no effect whether the lady was with the child or quick with child. Punishment also differs with element consent of the women. Miscarriage under section 312 is bailable, non-cognizable, and non-compoundable, but miscarriage under section 313 is non-bailable, cognizable and non-compoundable. The essentials to constitute the offence of miscarriage under section 312 and 313 are as follows: voluntarily causing a woman to miscarry, causing a miscarriage without a woman's consent, or miscarriage is not done in good faith to save life of woman. In the case of Sharif vs. State of Orissa, it was held that termination of pregnancy of a minor girl does not attract section 312, as the same was done in order to save her mother's life. The accused having instructed the minor to go for termination of pregnancy, but the minor went on his own to avoid the shame in society. Death of woman during miscarriage. It is provided under section 314 of IPC. Having knowledge of the consequence is not essential for an act to fall under this section. If miscarriage was being done with the consent of women, then it can be punished with imprisonment up to 3 years and fine. But if miscarriage was done without the consent of women, then punishment can up to life imprisonment or imprisonment up to 3 years and fine. Injury to unborn child. Section 315 and 316 are related to the birth of an unborn child. Section 315 is aimed at feticide, that is, a condition in which the fetus in the womb takes a human form. The difference with the infanticide is that infanticide is committed after delivery, but feticide can be committed before delivery. The offence under section 315 is non-bailable, non-cognizable and non-compoundable. Essentials of section 315 are as follows: act must be done before the death of the child, intention to prevent child from being born alive or to die after death, child not born alive or the death of a child after its birth. Exceptions: act done in good faith to save the life of mother won't come under this section. In the case of Alka Verma vs. State, the accused was charged with section 315 of IPC despite the child having taken birth. It was held by the Delhi High Court that when the child was taken birth, the accused cannot be charged under section 315. In case of Hira Hirdanbai and others versus State of Maharashtra, the accused was acquitted of the charge under 315 of IPC, and the court held that there must be sufficient proof that the accused has done such an act to prevent the child from being born alive or to die after death, and the act done must result in child not being born alive or death of child after his birth. Then only a person can be acquitted under section 315 of IPC. Abandonment and exposure of an infant. Section 317 of the IPC deals with the exposure or leaving of child with intention of deserting. The offence under the present section 317 of IPC is bailable, cognizable and non-compoundable. The term expose and leave means not giving the child proper protection, that is food, shelter, etc., leaving the child in danger. The section requires the following essentials: The person in question must be father, mother, or person taking care of child. The child must be under 12 years of age. The child must be intentionally be exposed or left in a place for deserting. This provision gives equal importance to schools, orphanages, as they are duty bound to take care of the child. The punishment under this provision can extend up to imprisonment of 7 years or fine or both. The explanation of the section that if the act is of leaving the child or exposing him with an intention to desert the child, if the death of the child occurs, the person shall be held liable for murder or culpable homicide as the case may be. Thank you.